Good afternoon. My name is Noa Mendelsohn. I'm the Executive Director and General Counsel of the Canadian Civil Liberties Association. Today, the Public Order Emergency Commission released its report to the public. The Canadian Civil Liberties Association appreciates the work of Justice Rouleau and Commission staff, but respectfully disagrees with some of his conclusions and will be pursuing our judicial review of the federal government's invocation of the Emergencies Act last winter. In January and February of 2022, protests in and around Canada, and in particular, the occupation of Ottawa and blockading of its streets, created significant disruption and hardship for Ottawa's residents, including reports of racist and homophobic intimidation and harassment, possibly worse, and concerns about ongoing underprotection of these and other marginalized groups by police. After this occupation had gone on for too long, on February 14th, 2022, the federal government handed itself the power to make laws with almost no constraint. The Emergencies Act allows the federal government to give itself the power to create laws without a first, second, or third reading before Parliament, without advance opportunity for input from the press, public, or opposition parties. In short, without the ordinary democratic protections of transparency, accountability, public review, and input, without a full debate before all elected representatives. In other words, the Emergencies Act can suspend the ordinary democratic process. This might be necessary in rare instances, but it was not justified last winter, and it is a dangerous power for any current or future government. The Canadian Civil Liberties Association spoke out then and is here today because we are concerned about democracy, about equality, about justice, and about rights. We want to make sure that all people, including in particular those with the least power, platforms, and voice, with grievances and concerns about injustice, can protest government and other institutions, that they can do so powerfully, peacefully, and yes, sometimes disruptively. This is critically necessary to ensure that everyone can learn about violations and stand together for the rights of all people in Canada. CCLA has decades of experience standing up for protesters, counter-protesters, and dissenters of all kinds with a wide variety of messages, engaged in mass marches on downtown streets, months-long protests, sit-ins, gatherings in parks, on sidewalks, in city squares, blockading businesses and railway lines, and picketing by striking workers. But the reason we are here today is not to support or denounce any particular protest or message. We are here to talk about power and about democracy. We are here to protect the rights of people in Canada. I want to extend my sincere appreciation to the two extraordinary people who have led CCLA's efforts at the Public Order Emergency Commission. I'd like to thank the brilliant Ewa Krajewska and her law firm, Henein Hutchison, and the brilliant Cara Zwibel, the Director of Fundamental Freedoms at the Canadian Civil Liberties Association. And now I'd like to turn the floor over to Cara to address Justice Rouleau's report.
Good afternoon. My name is Cara Zwibel. I am Director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association and was a co-counsel for the CCLA before the Public Order Emergency Commission. We are obviously still digesting the Commission's findings, conclusions, and recommendations, but wish to make a few brief comments at this time. First, we appreciate that the Commissioner has found that the high threshold for invocation was met, but that he has done so with reluctance. We are still examining the Commissioner's reasons and findings in support of that conclusion, and we'll have more to say in the coming days. It is significant that in his statement earlier today, the Commissioner noted that the factual basis underlying his conclusion was not overwhelming and that reasonable and informed people could come to a different conclusion than the one he did. Our view remains that this threshold was not met. Justice Rouleau acknowledged in his report that his task was not to assess the legality of the government's decision to invoke the Act. That is the job of the courts. And that is why we initiated and maintained our application for judicial review before the federal court. The court will assess the legality of the declaration and also consider the legality and constitutionality of the emergency measures that were put in place. And that application is to be heard in early April. We also note that the commissioner did take issue with some of the emergency measures that were put in place. His report deals in some detail, in particular with the economic measures, finding that there were problems in terms of the process that was established and the circumstances that it led to for those impacted by the orders. There are other important recommendations in the in the report related to future possible emergencies and future possible inquiries, and my colleague Ewa is going to talk about some of those.
Good afternoon. My name is Ewa Krajewska, and I'm a partner at Henein Hutchison Robitaille, and I, along with Cara Zwibel, were co-counsel for the CCLA at the Commission. The Commissioner makes a number of important recommendations with respect to the Emergencies Act and the future of these types of inquiries. The Commissioner states in his report that the Emergencies Act is anchored in the principles of the rule of law, constitutionalism, and public accountability. We agree. Invoking the Emergencies Act is an extraordinary and far-reaching decision. The Commission and the parties were able to do their work to assess whether the government met the threshold to invoke the Emergencies Act, in part because the government waived cabinet privilege on the inputs it received in coming to that decision. But as Commissioner Rouleau stated, this is only the fourth time in Canada's history when this has been done. The waiver of cabinet privilege is not mandated by the Emergencies Act, but it should be. It should be to ensure that the public understands and has transparency on how such a significant decision with such significant consequences has been made. The Commissioner recommends in his report that the government should be bound to produce all of the inputs to Cabinet and the ministers that it relied upon to invoke the Emergencies Act. He recommends that the Emergencies Act should be amended in order to do this. This is a very important recommendation that will ensure that any future government who invokes the Emergencies Act is held accountable for that decision, and that the public has transparency into that decision-making process to decide for itself whether the suspension of civil liberties is justified. We hope that the government will acquiesce to this recommendation and make this amendment. We thank the Commissioner and all of its staff and council for the work that it conducted on this inquiry. Thank you.
So I think we have some people on the phone. If there are questions, we'd be happy to address them now.
In English or in French?
In English or in French.
Please press *1 on the phone if you have a question. And currently, it appears there are no questions on the phone.
Okay, thank you.